Hello, everybody. Thank you for joining another Legal Wills webinar. I would like to wish everybody a happy new year, even though we're into the 16th of January, but this is our first webinar of 2026. So I would like to welcome everybody to the call. Hopefully you have some questions lined up and some thoughts about how our service might work, how our company works, how the documents work as well, whether you have any questions about any of the services and the documents that you can create through our service. Uh, I I always give a little bit of a background. Legal Wills, we've been around since 2001. We first went online, myself and my co-founder, Henry. We started the company back in 2001, and was it came about because we realized that these documents are very important. We know they're important, but we just weren't taking the time to get the documents done. So we thought there must be a better way, something that's more convenient and more affordable. And that was the genesis of the idea for Legal Wills. We were really the first online service, the first service that allowed people to just go online, go onto the internet and write their will, their power of attorney, and their living will. I'm one of the co-founders, and I am still the CEO of Legal Wills. And over the last 20 years, 25 years, we're into our 26th year. We've now done about 500,000 documents. I am based in Canada. I'm based in Ottawa, but we also do provide a service in the US, in the UK, and also in South Africa. And in Canada, we're across all provinces and territories, and we're bilingual in every province and territory. And we support England and Wales and every US state, with the exception of Louisiana. And as I say, also just in the last couple of years, we also rolled out a service in South Africa as well. I always start the live stream by giving some expectations as well. What I am, I've explained, the co-founder and CEO of. What I am not is I am not an estate planning attorney. I am not qualified to give legal advice. I'm not licensed to give legal advice. I am also not a certified tax pro. So if you have any questions about managing your assets, how you should optimize the structure of your estate, to minimize taxes, I can't give you that. In fact, generally speaking, when the questions come in, I cannot give you any personalized advice for your specific situation, because I'm not licensed and I'm not qualified to do that. The questions I can answer are questions about just general questions about the will, the power of attorney, the living will, and some of the other services that we provide, and also how you can use the service and what the company does, and how the company is designed to help people to get these documents done. Um, so please, by all means, any comments or questions in the chat, and I will also just bring up some of the questions that we have had prior to the call as well. I always like to start by knowing where everybody is located. When I did this webinar in December, there was at least one criticism saying that I was too Ontario focused and certainly too Canadian focused. I apologize for that. Anybody can tune in for this webinar. I just know that most of our customers are in Canada, and I personally, I'm in Ontario, so I have that lens. But I do apologize. That's not the intent of this webinar. I'm certainly not supposed to be just giving information based on Canadian law. So it is interesting to know where people are located, and certainly if you do have a question, it would be useful to leave that context for where you're asking the question from, because it could make a difference. There are differences in laws, from ranging from the age in which you can prepare a will, what your rights are, for common law, for example, very, very different across different jurisdictions, what you can and cannot do in a will. And certainly outside of the will, very different laws and documents associated with natural power of attorney and what will a living will service, a medical directive. So the living will is actually, well, maybe we'll get into that. So it would be useful anyway if you did ask a question to say where the question is coming from, and I might be able to um, give the answer in context of where you are. Um, so we've got some Ontario, we've got some BCs. For the most part, we are. We are in Canada. Most of the people who have made the comment are in Canada, but I'll still try and make the answers more generic if I can. I'm going to bring this one up. My investment account was set to spouse. How do I make sure it defaults to estate? And it's a bigger question. The question is really what assets are covered by your will and which ones are not. And I'm going to take a step back from that as well. So when you write your will, you do not typically, you should not write a list of all of your assets in your will. And there's a good reason for that. Two good reasons for that. Firstly, you don't know when your will is going to come into effect. It could be this week. It could be 50 years from now. You should update your will as time passes, but you really don't know when the will is going to come into effect. So if you started to list all of your assets in the will and walk around your house and think about all of your possessions, and it would require you to update the will every time you acquired a new asset, every time you bought a car or opened a bank account, and you don't want to have to do that. There's a signing procedure that's associated with making that will a legal document. So what you typically do in the will is you say, if there are specific items going to particular individuals, you're going to list those. You would say, I want my car to go to my nephew, but everything else is going to go to this person or divided between these people. That's your estate or residual estate. Everything that comes after the specific bequest is your residual estate, and you can pass that to somebody or divide it between people. So what is in that residual estate? And you may think, well, it's everything I own. It is, almost. Not quite, though, because there are certain accounts that may have a designated beneficiary as part of that account. And so in Canada, specifically, there are registered accounts. You can have registered accounts like an RRSP, or life insurance policies is another one where you would have a designated beneficiary on the account. So this question, I'm filling in the blanks here, but it's really saying that the beneficiary named on the account, this registered account, is the spouse, and I want to make sure it's not the spouse. I want it to go to the estate. And there are reasons why you would and why you wouldn't want to do that. The main reason why you would, there's a couple of reasons why it's a good idea to do that. Is firstly, the benefits of the asset can go to the beneficiary without it having to go through the legal process that the will goes through, going through probate and all of that. So it can happen a lot faster. It can go to the beneficiary on the account. The other advantage is that it is not going to be subject to the probate fees or the estate administration taxes that are levied on the estate based on the size of the estate. So if all of your investment accounts go to the estate and are then covered by the will, then it's all part of the estate covered by the will, obviously, and it will all then be subject to the probate fees and the estate administration taxes. So that's why people typically name a beneficiary on the account itself. If you wanted to change it, as this question, come back to this question, if you wanted to change it from the spouse to the estate, you'd have to speak to the account holder. The financial institution that holds that account would have the beneficiary named on it. You would have to speak to them and tell them that you want to have the beneficiary on that account changed. And you absolutely can change it to your estate, and then it will be part of the residual estate that's covered by the will. So that was a good start and a rather long answer. I will then to another question that I had previously. If I live half my time in 2 different countries, do I need a separate will, power of attorney, and a living will? So that's 3 very different documents. And I was going to talk about this at the beginning. So let's first of all explain what these 3 documents are. And if you know it, then please bear with me, because it's possible that there may still be a little bit of a misconception, even if you think you know what these documents do. There's no harm in having a high level refresher here. So the will only comes into effect the moment you die. It does nothing all the time you're alive. You can update it throughout your life. There is only one last will and testament. It's the last one you've written that was signed and is the last legal document before you die. And the moment you die, the will comes into effect. You've named an executor. That person is going to take responsibility for all of your assets and gather them up, distribute them to the beneficiaries. That's the will. Most people know what the will does. The power of attorney, and let's call that a financial power of attorney. There are very different types of financial power of attorney. In the context of our service, which is really part of their estate planning documents, and estate planning documents of the power of attorney is a general financial power of attorney that typically is written while you're capable and comes into effect if you were ever to lose capacity. It's still in effect while you're alive. The moment you die, the power of attorney does nothing. The person you've appointed as the power of attorney has no powers anymore because you've now died. We do get people come to us and say, oh, my mother has dementia now, and now I need a power of attorney. That's complicated. It's certainly not something that we can do, because you cannot prepare a power of attorney once you've lost capacity to prepare that power of attorney. It has to be done while you're competent, and it's usually written to come into effect after if you were to ever lose capacity. You had dementia, Alzheimer's, or even in a coma or something like that. You can't handle your finances anymore. You can have them come into effect immediately. You certainly can. But let's keep in mind what a power of attorney does. A general financial power of attorney allows this person to take control of all of your financial assets. So if you're still competent, that's not generally a good idea to have somebody having full, absolute control over all of your assets. You can create a power of attorney for a specific asset. And that's usually done like, I'm traveling, I'm backpacking through India, and I need somebody to sell my car that's back in Canada. I need to give somebody the power of attorney to do that. That's not really an estate planning document. It's not anything that we would do, but that kind of power of attorney does exist. So you would hear terms like a springing power of attorney. That means it comes into effect later on when you lose capacity. A durable or an enduring or a continuing power of attorney. These all really refer to when the document's going to come into effect. But for all of them, stop coming into effect the moment you die. The living will is made up of 2 documents, typically. It's your, what we call advance directives. It's how you would want to, what kind of treatment you would want to receive if you were ever in a terminal, irreversible terminal condition. Like you were in a coma, vegetative state. What kind of treatment do you think you would want to receive? You can't communicate it at that point, but you can write it ahead of time. It's an advance directive to explain what kind of medical treatment that you would wish to receive if you were in that situation. It also typically names a substitute decision maker, which is called something different in every jurisdiction. It can be a medical power of attorney, a healthcare representative. You're naming somebody who is authorized to make medical decisions on your behalf. So the doctors come out and they say, you know what? I don't think Tim's going to pull through. We can keep him alive if we keep his on mechanical breathing, and we've got him on the IVs, and we can keep him going. We can keep his heartbeat going, but he's never going to pull through. What do you want us to do? And without this document, what can often happen is that the doctors come to the family, come to the parents, and come to the siblings, and come to the spouse and the children, and say, "What do you want us to do?" And people can't agree. Uh, there could be ethical differences, religious, political, moral, whatever reasons you may have. People can't necessarily agree on what the best course of action is. So you name somebody to be that spokesperson for you. Uh, we often get asked, can you name joint medical decision makers? In theory, yes, you can, but you're not actually that far ahead if you do that, because the point of it is to remove that family conflict and say, you know what, I know you're not all going to agree, but this person is going to be my decision maker. So they're the three documents I've explained. So now let's go back to the question about, I live in two different countries, right? So do I need all of these documents for the two different countries? So the will applies to the assets. If you have assets in both different countries, in the two countries, we generally recommend it's a good idea to have a will written for each country in which you're holding assets. That's generally the best thing to do, because if you imagine if you were trying to probate a will in BC, it was written under the laws of Azerbaijan. The BC probate courts are not going to accept that, and vice versa. Like it's just not going to work. So if you have assets in multiple countries, write a will under the laws of each country in which you have assets, and the two wills are going to work together to cover your entire estate. That's our general recommendation. It may be countries that respect wills from different countries, but there's a lot of countries, and we don't know the laws of every country. So you can't go wrong if you write a will under the laws of the country in which the assets are held. The power of attorney, remember what that's doing. That's allowing somebody to handle the assets that you have if you were to lose capacity. Well, if you're in Canada and you want your power of attorney to handle your bank account held at RBC, and let's not make it local to Canada, you're in London and you have a bank account at Lloyd's of London, you're going to need a power of attorney written under the laws that bank is going to recognize and that bank is going to accept. So again, we generally recommend that you write a power of attorney that is going to be accepted by the financial institution where the assets are held. I'm sure if you walked into NatWest Bank in London and presented them with an Albanian power of attorney, they would struggle with it. So write a power of attorney under local law. The living will, that's a quirky one, because you have your advance directives and you've named your decision maker. You don't really know where you're going to end up in this coma. So it doesn't hurt to have multiple living wills, have multiple advance directives written under the local jurisdiction, but it has to be accepted by the attending physicians. So probably if you've clearly laid out what your medical wishes are, and it's written under a BC representation agreement, and you're in Mexico, and your wishes are legal in Mexico and clearly understood, chances are, I would imagine, that the attending physicians would respect that. They're not going to ask for a local advance directive to be written, and they will probably respect the wishes of your appointed decision maker. Can't guarantee that because I can't speak for every hospital in the world, but it kind of makes sense. Like if you were traveling and you were in that situation and you ended up in a coma in a hospital, chances are your living will is going to be respected in that area. You can't write a living will for every country you're ever going to go to. So 3 different documents, really 3 different answers. Let me just quickly go to the questions that are coming in. Okay, so with regards to witnessing a will signing, who is or who is not permitted to witness in Nova Scotia? I'm not going to quickly look up Nova Scotia. I'm going to give an answer that's fairly general, and I'm assuming Nova Scotia aligns with this. So your witnesses, primarily across all of the documents, they cannot benefit from the document. So in the case of the will, they cannot be a beneficiary, right? So anybody who stands to receive something from the will cannot be a witness. Obviously, there's a conflict of interest there. In most jurisdictions across most countries, the spouse of a beneficiary cannot also not be a witness to the signing. Not just the beneficiary, but it's also the spouse of a beneficiary. If you're not sure, like, well, I'm not sure it's the spouse, they're kind of common law, well, it's his girlfriend or boyfriend, I'm not quite, just don't do it. Don't find somebody who is completely nothing to do with anything, any of the beneficiaries who are going to be receiving something. Interesting. Oh, and the other thing is they have to be an adult. They have to be mentally competent. They have to have those same criteria that the person writing the will does. So, yes, an adult, mentally competent, not a beneficiary, not a spouse of a beneficiary, not gaining anything from the will. There's also a very common question. It's like, well, what about my executor? Can my executor be a witness? Yes, they can. In fact, that's very common. It's very common. If you walked into a lawyer's office to write your will, very many times the lawyer will present themselves as the executor and they will serve as a witness to the signing. So executor, no problem. It's just the beneficiaries. And the one addition to that point is that in many jurisdictions, in most, if your witness is a beneficiary, it doesn't void the whole will. It just means that that witness is not going to be receiving what you've said they're going to be receiving in the will. They've just counted themselves out because they served as a witness. They counted themselves out as the beneficiary. So it doesn't make the will completely null and void, although you're not doing yourself any favor because it's going to open itself up to challenges. It's like, well, that witness, and so there's what happens legally and what happens practically. So there's a good chance that if it's contentious and your witness is a beneficiary, you've just created a bit of a mess for yourself. So somebody entirely independent of the beneficiaries, find them. The other thing is, like, who does it have to be? Well, does it have to be a lawyer? No. Does it have to be a justice of the peace or an RCMP officer or, somebody of any kind of professional standing? Absolutely not. There's no like professional standing qualifications for a witness. It can be your friends, it can be your neighbors. For mine, I had my friends come over for dinner one night. I signed my will, asked them to sign it. The witnesses do not have to watch. They do have to watch you sign it. They don't have to read the will. They don't have to read it, check it over, anything like that. They have to watch you sign it and then sign to say that they saw you sign it. That's what they need to do. They're not checking it. So yes, there's no professional requirements for a witness. Okay, so questions are coming in now. How do I Another question: how do I protect their legacy? I will pass on to my children from spouse in the event they separate or get a divorce later on. Yeah, that's good. Right. So this does come up, right? So if you've left something to an adult child, um, how do you protect the inheritance that they're receiving if they were to get married or divorced or separate? You don't want half of that, let's call it a family legacy that in theory should be passed down through the generations. You don't want half of that to be lost in a separation or divorce. We actually do have a clause in our wills called limited interest of spouse, which does ring fence any inheritance that goes to an adult child. It is a standard clause. It's not bulletproof. We can't guarantee it, that it would do that protection, but it is in the will, and it does. That's the intention of that clause, to provide some protection in the event that there was a marital dissolution. Um, this one, good morning from Vancouver. I want to set up a fund for my grandchildren. I only have one so far. How do I set this up so that the parents won't have access until the child needs it? Yeah, so this is a good question. So if you leave an inheritance to a young child, a minor, obviously you can't leave $1 million to a year old. You can't. The law doesn't allow you to leave a sum of money to an infant. What happens is that somebody has to manage that on their behalf. So a trust is set up, and a trustee is going to be looking after that until the age that you have determined that you feel that beneficiary should receive the proceeds of the trust. You can even split it up. You can say, I want them to get a third at 21, a third at 25, and the remainder at 28. You can certainly do that. Is in place. The trustee is responsible for it and looking after it, and will balance the needs of the child as they're growing up with their responsibility to protect the fund, so that there's something left when the grandchild becomes old enough to receive it. So that's their responsibility as a trustee. Within the will, if you create a will using our service, the executor of your estate is by default going to be the trustee of that grandchild's trust. And so you would name an executor, and they will be setting up that trust fund for the grandchild and manage it on their behalf. They can use some of the funds for things like medical needs, education, expenses, living expenses as they're growing up, but it's the trustee who's going to be releasing those funds. If you set up a parent of that grandchild as the trustee, then the trustee still does have a responsibility to manage that trust in the best interest of the grandchild. But there's a lot of gray areas. Like, what's in the best interest of the grandchild? Well, a family vacation to the Cayman Islands, that's in their best interest, or an addition to the house. There could be um, some areas that aren't as clear cut, or there could potentially be some kind of conflict of interest there. So if you have an independent person acting as the trustee, then it's less likely to be contentious. So the answer to this question is, don't set the parents up as the trustee. Have an independent person work as the trustee. This one, it is understood that my business is part of my estate, or does this need to be managed in a different fashion in my will? So I'm going to answer this from a Canadian perspective because I'm most familiar with how it works in Canada. So remember what I said about probate fees, estate administration taxes. They're levied on the size of the estate. So if you own shares in a business, let's assume this was a corporation. So it's a corporation and you own shares in that business. Now, technically, the shares that you have in that business are they're your assets that you own. They're the same as if you had shares in Apple and Facebook and Google. They're shares that you own. You happen to have shares in the corporation that you own. So if those shares become part of your estate, they're going to be subject to the estate administration taxes and the probate fees. So the answer to this question is it part of your estate? Yes. The answer is yes. They are assets that you own. So should it be managed differently? Probably. So what you can is prepare a separate will, a secondary will, a corporate will, a dual will. It's a separate will that is written just to cover those corporate assets, and that will shelter those corporate assets from the probate fees and the estate administration taxes. So by doing it that way, there's going to be less of a tax burden for your beneficiaries. If you went to a really good estate planning attorney, this is how they would set it up for you. They may charge you a lot to do it, but what they charge you will probably almost certainly pay for itself in the fees that have been saved. If you go to somebody who's not super skilled in doing this, it's a sophisticated approach to estate planning. I think it's a good thing to conclude on and understand what we are and what we're not. We don't do this. It's complicated, it's sophisticated and nuanced, and needs to be managed and understood really well in order to do this. And a self-service tool like ours, where we provide a will for around $50, is not going to give you the same kind of estate planning advice that you would get from a $2,000 lawyer who prepares your will. So we think it's really important that you have a will. And if getting this done is adding to the procrastination and making you put off preparing your will, then one approach could even be to use our service to write your will, get it done, because you can literally get it done by dinner time today, and have your will, and then think, you know what, though? What I'm going to do down the road is I'm going to speak to an estate planning attorney who really knows this stuff, find out how much they cost, find out how much money could potentially be saved, and that might be a direction I go in. And you'll be able to make that evaluation yourself. But don't not have a will in place. So you can write your will with us, and then if you do some research, do some reading, look at the cost savings, look at how much the value of the assets, the size of your corporation, how much it would be worth, put it into a probate fee calculator and see what the probate fees will be incurred if all of your corporate assets were probatable assets. Do some of that investigation yourself and then make that decision. But in the meantime, get your will done. You can do it conveniently, affordably, using a service like ours. There's one question, and I don't want to avoid it, but I don't know. I'm not. I answer, and I'm more than happy to admit to that. And what I want to do is look into it and provide a more complete answer on a future webinar. And the reason I don't know the answer is primarily because I know more about wills than I do about advanced directives. And secondly, medical assistance in dying, those laws are so fluid and moving so quickly and so different across different provinces, different countries, different states, that it's just really difficult to stay on top of how the law changes. And so by all means, you can email us at support@legalwills.ca or uslegalwills.com, legalwills.uk. Email us and we can find and tell us where you are, and we'll be able to provide you with a more complete answer to that, but I'm not going to try and answer that one on the fly. So with that, I hope that was useful. We have got to the end of the half an hour. So I'm going to also just conclude by saying that all the emails I get, if you do have any other questions, you can by all means email me. I'd be more than happy. If not me, we have even more qualified people than me on our team who will be able to answer questions. And so tim@legalwills.ca is the best place to get in touch with me. If it's a more generic question about your account, how your account works, and then by all means reach our support team. They're very responsive, and they would be more than happy to answer any questions you have. So with that, I really appreciate everybody attending. If I didn't get to your question, please send it to me and I will respond. And I know we are having another webinar in a couple of weeks. I will have a guest on that webinar, so it's not just going to be me talking. And I think it's going to be really interesting. I'm looking forward to it. And so, yeah, we're going to have a guest on the next one in a couple of weeks' time, and hopefully you'll be able to join us then. So thank you so much for your time. I hope it was useful, and I'll speak to everybody in a couple of